Good morning, all protocols observed. Welcome back to Judicial Education Week 2024. This is day 4 of our exciting JAI week, and we hope that you've had an enjoyable time with us this week. It is my pleasure this morning to introduce the Honorable Madam Justice Maria Wilson, who is joining us from the Court of Appeal of Trinidad and Tobago, and who will be leading us in an exciting and thorough presentation on courtroom management and avoidable delays. Today's program, which includes Justice Wilson's bio, will be shared in the chat. So I hand over now to Justice Wilson. Good morning, Judge.
Good morning, everyone. I feel honored and privileged to be invited to present this topic, courtroom management and avoidable delays, on JAI's Week 2024. This topic is very close to my heart because I had to deal with the consequences of delay throughout my professional career. When I was a defense attorney, a prosecutor, a trial lawyer at the International Criminal Court and the International Criminal Tribunal for Rwanda, as a High Court judge here in Trinidad and Tobago, and now as a Court of Appeal judge. After a few years as a High Court judge, I felt so strongly about addressing the delays in our system that I compiled a table of all the factors which I thought contributed to delays, and I spoke to our Chief Justice about it. I actually went into his office and said, I do not want to be part of a failed criminal justice system. That led with lots of engagements with my other colleagues and with the Chief Justice and lots of changes. So that's the reason I feel so passionate about it. And I hope that during the course of this discussion, we will share the best approach to dealing with this issue. I don't profess to have all the answers, but I think we could interact and engage with each other about this ongoing challenge of delays and the best way to address it. So I look forward to our discussion. I understand that the program has towards the end of my presentation to entertain questions. So I will go along with that format. I have a present point presentation, and I will now begin that. Now, it is the duty, let me make sure I'm on the first, yes. It is the duty of judicial officers to manage the cases in the courts to which they are assigned. Let me just having a little bit of problems with moving on. Yes. The case management function of judicial officers is clearly articulated in the Criminal Procedure Rules 2021 of the Turks and Caicos, which came into force on the 1st of August 2021. In those rules, it defines what a court is. And it defines court as being, except where specifically stated, to mean the Supreme Court of Turks and Caicos or a magistrate's court, as the case may be, in the exercise of the criminal jurisdiction and includes a judge or magistrate. Section 3 of the rules goes on to say that these rules shall apply to the management of all criminal cases in the Supreme Court and the Magistrates' Court. Now, Section 4 assists us in indicating what the overriding objective of these rules are. So the overriding objective of these rules is to ensure that criminal cases are dealt with justly. And Sub 2 goes on to say it is a duty of the court and all parties and participants at every stage of the proceeding to advance the overriding objective. And that includes sub 3, dealing with a criminal case justly. It includes A, dealing with the case efficiently and expeditiously. B, dealing with the prosecution and the defense fairly. C, considering the interest of the parties, witnesses, victims, and jurors, and keeping them informed of the progress of the case as necessary. D, ensuring the protection of rights of a defendant. E, ensuring the appropriate information is available to the court, particularly when bail and sentence are under consideration. And F, dealing with a case in a way that takes into account, 1, the gravity of the offense, 2, the complexity of the issues, 3, the consequences for the defendant and others affected, 4, the needs of other cases, and 5, allotting a case an appropriate share of the court's resources, while taking into account the need of resources to other cases. Sub 4 states that the court must seek to give effect to the overriding objective when the court exercises any discretion given to it by these rules, or where it interprets the meaning of any ordinance, rule, or practice direction. I'm sure all of you are very familiar with your criminal procedure rules, but I still feel it's necessary to just quickly go through them. Section 4 deals with the fact that the rules also provides for each party to actively assist the court in fulfilling its duties. So whereas the duty is for the judicial officer to manage their court, they're not alone in this exercise. It is for every party to actively assist the court in fulfilling its duty. And sub 5 says that each party shall actively assist the court in fulfilling its duty under sub rule 4, that's the overriding purpose, whether or not the court has given a direction and may apply for direction if needed. Sub-rule 6 says it's the duty of the parties and participants in a criminal case. So it gives a responsibility to parties and participants in a criminal case to A, prepare and conduct the case in accordance with the overriding objective, B, comply with the rules, any practice directions, orders, and directions made and given by the court. C, immediately inform the court and all the parties of 1, any significant failure, whether or not that party or participant is responsible for the failure, to take any procedural step required by these rules, a practice direction or an order or direction made by the court. 2 deals with that anything that may affect the date or duration of the trial. 3, anything that may significantly affect the progress of a case in any other way. So there's that duty to inform. Section 2 goes on to define what does a party mean and also who is a participant. So a party includes both parties to the proceedings and any attorney on record for that party unless any rule specifies, or it is clear from the context that it relates to the defendant or to the attorney only. And then section 2 also defines participants, and there's some overlaps here, which means any person who takes part in and has any role or function in the proceedings of the court, and includes, and it's listed from A to I, parties to the proceedings, a witness, a judge or magistrate, a police officer, a registrar presiding over the proceedings, an interpreter or other person assisting the proceedings, a representative of the press, court staff, and any other person directly involved in the proceedings whom the court considers appropriate. Now, to truly understand and appreciate the pivotal role played by judicial officers, we must consider it in a wider context. Judges and other judicial officers took an oath of office on appointment to their office. The words of that oath include that the judicial officer, and I quote, will do right to all manner of people after the laws and usages of the Turks and Caicos Islands without fear or favor, affection, or ill will. A judicial officer thus has a professional, moral, and ethical obligation to uphold the oath of his or her office. Now, in the management of cases, judicial officers must also be mindful of Section 6(1) of the Constitution, which provides as follows. If any person is charged with a criminal offense, then unless the charge is withdrawn, the case shall be afforded a fair trial within a reasonable time by an independent and impartial court established by the law. And I want to emphasize within a reasonable time. So in the light of the above, judicial officers have a great responsibility to ensure that cases are completed in the shortest possible time to ensure that justice is done. Now, it is important for judicial officers to manage courts and avoid delay because of the various roles and purposes of courts. And I want to go through that with you now. These fundamental purposes and responsibilities of courts apply regardless of the specific jurisdiction in which a court functions and provides both the philosophical and the legal framework for the daily work of all court leaders. And I got that and what is the various purposes of court from someone by the name of Ernest Freeson, who was a senior court management consultant. So if you were to ask me what role does a court play, and I could answer it in one line: to uphold the rule of law. But Ernest Freeson said it can be broken down to include the following: to promote justice in individual cases, to ensure public perceptions of justice in individual cases, to provide an impartial forum for the resolution of legal disputes and the enforcement of judgment by the court, to protect individuals against the arbitrary use of governmental power, to provide for a formal record of legal status, to deter criminal behavior, to rehabilitate individuals convicted of crime, to provide for the separation of convicted individuals from society where necessary, to provide vulnerable populations, abused and neglected children and adults, from the abuse of power in any form, to provide access to all who seek court intervention, to promote coordination with justice, public health, social service, and other agencies to address common problems underlying the court's criminal and civil caseload, including substance use and mental health. Thus, the courts exist to do justice, to guarantee liberty, to enhance social order, to resolve disputes, to maintain and to protect fundamental constitutional and legal rights, promote the rule of law, to provide equal protection, and to ensure due process of law. As I said before, these fundamental purposes and responsibilities of courts apply regardless of the specific jurisdiction in which a court functions, and provide both the philosophical and legal framework for the daily work of all court leaders. And I'm grateful for Ernest Friesen for his thoughts on this. So when a judicial officer is deciding whether or not to grant an adjournment, it's not just about the adjournment. It has to be looked at in a greater context, in the context of the role and purposes of the court and what people seek from the courts. So to move on, as I said before, whilst the duty is with the judicial officer to in fact manage their court, the attorneys have an active role to play. Your rule states that the attorneys should in fact actively assist the judicial officers in case management. And I feel that all attorneys should be mindful when they're in court of the code of conduct for attorneys. And this includes as follows. Part 26 of your code of conduct states as follows. An attorney must at all times, with due courtesy to the court before which he is appearing, must act with due courtesy to the court before which he's appearing and to the opposing counsel. He must in every case use his best endeavors to avoid unnecessary expense and waste of court's time. Part 4 of that code also states this. An attorney must discharge his duties to the court, his client, members of the public, and his fellow members of the profession with integrity and in accordance with his code. In the performance of his duties, an attorney shall not act with inexcusable or undue delay, negligence, or neglect. So in the course of cases, I want to emphasize that attorneys should always be mindful of the code of conduct that governs them. So it's not just the judicial officers who deal with the case management. It is the duty of the judicial officers to deal with it. But the attorneys also play a significant part. Now, again, I think every application for an adjournment or issues causing delay should be looked at in the context of the consequences of the failure of courts to carry out their role and function. So what are these? I have created a list of them, and I'm happy for you to add if you wish. So some of the consequences of the failure of the courts to carry their roles and functions in having expeditions hearing in both civil and criminal cases are as follows. Citizens lose faith in the administration of justice, and this might result in them refraining from resolving legal issues through the court system. Failure to use the court system can impact on law and order in the countries to which it applies, and some citizens might opt for non-legal options to resolve issues. Failure to deal with criminal cases expeditiously creates the appearance that there are no consequences for committing crime and therefore no deterrence for would-be criminals. In Trinidad and the man on the street, or all in our talk shows, that is the sentiment which has been expressed. Long delays in dispensing justice in criminal cases could also result in the inability to rehabilitate individuals who were remanded in jail pending hearing of their matters because they're exposed to seasoned criminals. Now, in criminal matters, one of the many aims of justice is not just to punish individuals who commit crime, but one option which a judicial officer has is to rehabilitate in the proper case. But if justice is taking very long to be dispensed, those same individuals who might have been worthy of being rehabilitated, as I stated, have now spent so many years in jail. They have been exposed to seasoned criminals, and the option to rehabilitate will not lead to the results one would have hoped for. The other thing is, if a system does not work efficiently and expeditiously, it means that there is no protection to vulnerable populations through the court system, or such populations have to wait a very long time to obtain protection from the court system. Then there's the perception of lack of access to the courts. Members of the public know if there's a failed system and it takes so long for matters to be dealt with, their perception is they no longer have access to the courts. I mean, literally they might have access, but the length of time which cases might take might prevent them from having true access in the true sense of the word. Then there is the cost. There's an economic cost to litigants who have to travel repeatedly to court, to take time off work. I've been in matters where witnesses come almost every day to court to give evidence. And they're told, because the matter goes on for longer than expected, extensive cross-examination, they're told, sorry, I cannot take this witness today, and you'll have to come back tomorrow. Those litigants need to get money to get a taxi to come back. They need to go to their employers and ask for a day off. Some witnesses lose their jobs in the course because of repeated absence from work due to their attendance of court. Now, if that happens with jurors, we have legislation, I'm sure you do, to prevent employers from taking such drastic actions. But does that obtain in the case of litigants who are witnesses? Does it obtain? So that there's that economic cost. Further, there is mental and emotional stress, not just to litigants, but to lawyers, due to the fact that there's no immediate resolution of legal matters, and there's no hope for finality of litigation. So I have an example of that. There's a particular matter which a relative is involved in, where he is suing some other persons. The first time the matter comes up, and it's not in this country, the first time the matter comes up, the other side applies to the court for an extension of time to put certain documents in. They did not obey by the rules to provide their submissions within the stipulated time. What does that judicial officer do? The judicial officer extends the time to another 6 to 8 weeks. It leads to frustration. It leads to uncertainty. Litigants feel that they are wasting their money. And often in such situations, they have to pay their attorneys each and every time they have to appear in court. So yes, it's an economic cost not only to litigants, but to lawyers. And it causes mental and emotional stress because they cannot see the end. They can't see the light at the end of the tunnel. There's no date where the matter would be finally dealt with. There are many more consequences for a system that doesn't work efficiently, and there's as follows. Witnesses die. Witnesses get threatened. Witnesses lose their memories fade, or they opt to leave the country. Now, I'm sure in your law, as in ours, there are alternative ways of presenting that evidence, but you'll immediately agree that those ways are not as effective as having the person there physically. And when memories fade, the other side can take advantage of that and point out the inconsistency in what the witness is saying at the trial and what the witness stated previously, whether in their statement or in a prior hearing. For example, when there were preliminary inquiries. And should such a witness just wait around indefinitely, or should they get on with their lives? And for example, opt for better economic opportunities by leaving the country to work abroad. So at the end of the day, such evidence is weakened. And I'm sure in the case of criminal matters, a state attorney might be wondering, does it make any sense to continue with this case? Of course, they have no choice but to do so, because on paper, there's evidence to prove the particular charge if it's a criminal matter. Now, that is not all. Witnesses who were called because they have observed traumatic events are being asked to come to court 2, 5, 10 years later to repeat the events which they have observed. Now, those are witnesses who have amazing memories, so they don't suffer from their memories fading. But what they do suffer from is being re-traumatized by having to repeat events which they would rather at this stage to put behind them. They can't move on. That's sometimes witnesses say, Judge, I don't want to give evidence. Why don't you want to give evidence? I have moved on. I don't want to be taken back to there. Sometimes they might even say, I've forgiven the accused. The system puts them in an awkward situation where they prefer not to participate anymore because too much time has elapsed. What about the high cost to a country where a legal system is sluggish, doesn't move fast enough? Well, governments pay all their state, have to pay the salaries of all the state employees. But apart from that, they have to pay for the upkeep of prisoners who are on remand for years. There are prisoners in certain countries that are on remand, not just for 5 years, 10 years. and in some cases over 10 years. Can you imagine the amount of money that goes into maintaining these prisoners? And in any event, is it fair? Is it fair in the face of presumption of innocence to have such persons who are accused of crimes remain in prison for an inordinate time? Do we forget about the presumption of innocence? I remember when I was a high court judge in the criminal jurisdiction, I felt embarrassed when I heard the length of time that persons are incarcerated on remand. They have not been able to have a trial. Should our system be endorsing this sort of situation? Because you will all agree with me that after a number of years, things become so normalized that people think that that is the norm and we accept it. I think we ought not to ever think that this is okay. And actually some members of the public, when you hear them on our radio stations, they ignore the presumption of innocence. They feel once the police has charged this individual, they have a right to be kept in prison for all those years. This cannot be if we truly believe in the presumption of innocence. Now, are there any other consequences for a system that's not effective and is not efficient in dealing with cases? What it means, that system is unable to deal with serious offenses effectively and expeditiously. For example, murder, rape, robbery, possession of cocaine, sexual offenses, corruption. They're not able to effectively deal with such cases, and they simply hang in the air, and they're in abeyance for a number of years. Citizens don't feel any safer, especially if sometimes there are people escape from prison. And for those accused persons, they're disgruntled. The system must create some anger within them and turn them into persons that they might not have been turned into from spending such a long time in prison. Now, there is also, of course, now people like to think that lawyers just want a lot of money and they're happy if cases go on and on. But I don't think that's always true. A lawyer who has been involved in a delayed case, it means that that lawyer can lose his income because he doesn't have enough time to focus on other cases. He spends instead excess time working on delayed cases and has no idea whatsoever when these cases will definitely be dealt with. So I think even the lawyer who wants to make a lot of money, after some time, he will realize that it doesn't help him. It doesn't help his practice. It doesn't help his ability to organize and structure his practice to ensure he can divide his time between his other matters. And then looking at it in a larger sense, this is also a disincentive to foreign investors, because a legal system that doesn't work effectively and efficiently, it means that there's a difficulty in upholding the rule of law. That is a disincentive to foreign investors who don't only need the assurance that there's good electricity and roads and an internet service to be able to live in a country, and water, it goes beyond those factors. A foreign investor, an investor who wants to set up a business in a particular country, they also need to be assured that there's an effective and efficient legal system where they can resolve any disputes that might arise in the course of dealing with their business. So it's a disincentive to them to even think about doing business in a country such as this. But it's not just the fact that the system does not work efficiently and expeditiously for them, but of course, they will be wary of exposing their employees and themselves to a country where they do not feel safe, where they have to depend on armed guards, where they have to have burglar proof, where they have to decide when to go out, not to go out at nights, what roads to use, to constantly have maybe a bodyguard with them. They will take all of that into consideration, I feel, when deciding whether or not they choose to invest and build up a business in countries where the system doesn't function effectively. Of course, it can also lead to a brain drain, where citizens who are able to contribute significantly choose to live in other countries. They can't take it anymore. They don't feel safe in a country where the system does not work effectively and expeditiously. And my last point on this, and I'm sure you could think of many more consequences, is the inability of a country to have an effective and efficient and legal system can ultimately lead to a failed state. It might sound like an extreme conclusion, but that is my opinion. You might differ from me on this point. So that, again, sometimes when a judicial officer is deciding on whether to grant an adjournment or extend the time for a party to take a certain act in the course of case management, we don't always see the big picture. We just see the application before us. And I think it's helpful to see it in this wider context and to recognize the pivotal role played by each judicial officer, so that it would make us think once and twice and three times before it readily agrees to an adjournment. And it matters not who is before the court. It matters not if it's a senior counsel, as we call them here, or King's Counsel. Everyone has to comply with the rules, and they have to actively assist in case management so as to ensure that the system works. I was looking at the trends in the Caribbean region, and I decided I'd refer to what Justice Winston Anderson, a judge presiding at the Caribbean Court of Justice, had to say in a keynote address he gave on the 5th of September 2024 at the 16th annual Lloyd Barnett Lecture Series, which was entitled Criminal Justice Reform: Achieving a Modern Criminal Justice System. In that speech, he reflected on the state of crime in our Caribbean region. And I quote from what he said. He said as follows: "A recent study done by our Judicial Council at the CCJ confirms what all Caribbean people know. there is an alarming pandemic of serious crimes in the region: murder, rape, manslaughter, armed robbery, assaults, burglary, human trafficking, money laundering, and trafficking in narcotics. Our countries have the dubious distinction of dominating the list of nations with the highest murder rates in the world. Typically, we claim at least 5 of the 10 top spots. Caribbean countries that make regular appearances include Jamaica, I have to say, admit, Trinidad and Tobago, Guyana, Belize, St. Vincent and the Grenadines, and St. Kitts and Nevis. Take our 2 most populous English-speaking countries. In the decade since 2013, there have been an average of 468 murders per year in Trinidad and Tobago, making for a total of roughly 5,616 homicides in a country of 1.5 million people. There have been, on average, 1,300 homicides every year in Jamaica, with 2.8 million people, making for a grand total of 13,000 murders in the decade since 2013. By comparison, 4,600 American soldiers died in the Iraq War. 2,996 people were killed on 9/11. And less than 600 people were killed in the Troubles in Northern Ireland. Singapore, a country with a population of approximately 5.8 million people, over a similar decade, had approximately 719 murders. Additionally, Justice Anderson also commented in that speech on the fact that, and I quote him again, the judicial administration of criminal justice is in perilous shape. In some of our countries, our citizens spend 5, 10, and sometimes over 15 years on remand. This is wrong. This is very wrong. It makes a mockery of the constitutional presumption of innocence and the constitutional right to fair trial within a reasonable time. The long delays result in victims being re-traumatized and sometimes in reprisal killings. Persons found not guilty after a decade on remand often lose the most productive years of their lives, wrongly held behind bars. Now, goals must be set to address the issue we are faced with. And goals were addressed at the CCJ Academy of Laws at their 7th biennial conference, which was held in October 2023. That conference concluded with the adoption of the Needham's Point Declaration on Criminal Justice Reform in the Caribbean, Achieving a Modern Criminal Justice. It suggests a number of factors which the criminal justice system and the different countries should adopt in the coming 2 years in order to improve the effectiveness and the efficiency of criminal legal system. I was fortunate to participate at that conference and to present. I'm now on a monitoring committee along with many others, including Justice Winston and Justice Suhan, where we monitor the progress of different Caribbean countries in achieving different milestones, which we feel would assist in improving legal systems. Of interest as well, and of concern to us all, should be the 2015 UN Sustainable Development Goals, and in particular Goal 16, which is to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. These goals are meant to be achieved by 2030. And you will all immediately agree with me that if we have a system, a legal system, which does not work effectively and efficiently, we cannot promote peace. We cannot promote a peaceful society. And there will not be access in its truest sense to justice for all. So moving on now to what are the possible tools then that we have that might adequately address the issue of delay. Well, I would say some delays are avoidable and others are not and possibly require intervention by the legislature or the executive in terms of putting more resources in place. Now, I have to say that I was very impressed with Turks and Caicos criminal procedure rules. It is very comprehensive. It provides, amongst other things, timelines within which certain acts must be done. We have similar rules, but not with all those timelines. But at the end of the day, we might have all the tools possible. And I'll show you that in Trinidad, we have employed and introduced a lot of the tools suggested in that Needham Declaration. But I'm of the view at the end of the day, it comes down to how the particular judicial officer manages their court. Do you feel that because two parties on opposing sides come and apply for an adjournment and both of them agree that they have no objections, is that a basis for granting an adjournment? Should the judicial officer grant an adjournment? In my view, there should be a policy of no adjournments. Of course, we have to bear in mind that the decision on whether or not to adjourn or to extend time for filing submissions, often it does involve the exercise of a discretion. And such a discretion should be exercised reasonably. But I want to say that the tools are not to blame, and the tools are there, but it really comes down to how a judicial officer manages his or her court. That officer is a person who has the main responsibility for preventing delays. It falls in the laps of such a judicial officer. I remember when I became a High Court judge, I got some pertinent advice from a retired judge before whom I used to appear all the time. And this is what he had to say. Very simple. Always be in control of your court. Do not let the attorneys take over your control. You have to be in control. So I wanted to give an example of some cases where the issue of applications for adjournments came up and how they were dealt with. I want to start with a case which I did recently. Is a case, and as a court of appeal judge, is a case of the Chief of Defense Staff, the Attorney General of Trinidad and Tobago against someone by the name of Myers. Now, with the facts of the case, the appellant missed a 21-day deadline for the filing of his written submissions and had to file not just an application for an extension of time, but for relief from sanctions. Since our CPR Rule 64.9, sub Rule 5, contains a sanction of dismissal. It provides as follows. The written submissions in support of the appeal shall be filed within 21 days of the filing of the notice of appeal, failing which the appeal shall be dismissed unless the court extends the time for the filing of the submissions. Now, in this case, it was a procedural appeal. So, CPR 26.7 governs relief from sanctions. It states as follows. The application must be made promptly and supported by evidence. That is in 26.7 sub 1 and sub 2. Number 2, the threshold test is that it must be unintentional breach with a good explanation and general compliance. That's 26.7 sub rule 3. And number 3, once the threshold is passed, the court will have regard to rule 26.74. Now, rule 26.73 establishes a threshold test. In other words, the 3 conditions stipulated in that rule must all be satisfied before the court may grant relief. If any of the conditions are not satisfied, the court cannot grant relief. If the conditions are satisfied, however, the relief is not automatic, but the court may grant relief, and in considering whether to do so, must have regard to the factors outlined in Rule 26.74. See Civil Appeal 65 of 2009, Trinidad Oil Limited, and another's against Chris Martin. The court did not have an issue with promptitude, the application being merely 3 days out of time. On the issue of intentionality, the court, and that's me, found that the breach was intentional as the affidavit did not depose that the deadline was missed because of inadvertence. The excuse was that the counsel was involved in other matters. Counsel was very busy. The court inferred, therefore, that the appellant was well aware of the deadline and did nothing about it. There was a deliberate positive intention not to comply as per the Trinidad case. The explanations given included the following. A, overwhelming workload. But doesn't everyone have overwhelming workload? Anyway. B, junior counsel was out of the country. C, the deponent was out of the country. D, counsel was focused on the certificate of urgency and arguing that application. I found that the appellant did not satisfy the threshold test of a good explanation and intentionality, and therefore dismissed the application and ultimately dismissed the appeal. Some other examples of cases, and this is in criminal law, the case of Diane Burgess against Thalia Silverton, where the respondent was charged with larceny and housebreaking in January of 2004. 3 years later, in January of 2007, the magistrate dismissed the complaints due to the non-appearance of the complainant. On appeal, it was noted that though an excuse for the absence was given, it would not be the only consideration before the magistrate. In this regard, Justice of Appeal John, as he then was, quoted from paragraph 11 and cited the then Chief Justice de Labastide in the case of Housen and Tyson, 3 TTLR at page 782 as follows, and I quote, "Clearly, the magistrate must have regard also to the history of the matter and to the number of adjournments, the length of time since the charge was laid, and whether or not the complainant has appeared and been ready to proceed on previous occasions, and to what extent the adjournments and the resulting delay have been due to the complainant or to the accused. These are all matters which should be taken into account. There may be others. We emphasize that the matters we identified must not be regarded as exhaustive." Close quotation marks. But Justice of Appeal John continued in that same case at paragraph 17 to say as follows, and I quote, "Magistrates must not be too anxious to fall prey to applications by defense counsel to dismiss a case simply because a complainant is absent. They must bear in mind that there is an important public interest in the outcome of all criminal prosecutions, more so where the offense is a serious one. The public has an interest in criminal trials. The public interest in criminal trials is that the defendant should be convicted where it is proven that he has committed the offense, and he should be acquitted where it is proven that he has not committed the offense. The interests of justice are not served when the matters are dismissed without a trial. It erodes public confidence in the criminal justice system. Magistrates must always be alive to this." Moving on to another example, Magistrate Appeal number S083 of 2016, PC Sheldon Calendar against Kevin Neptune. This matter was fixed for trial on 2 occasions, and in those circumstances, the Court of Appeal affirmed the magistrate's decision to dismiss for want of prosecution. In that case, the respondent was charged with stealing $600. 2 years later, the magistrate dismissed the charge for want of prosecution. The complainant in that matter never appeared, and the matter was set for trial twice. Once under the prosecution's appeal, it was held that the dismissal was a reasonable one based on all the circumstances surrounding the matter. So it is very clear that each case has to be looked upon on its own facts. There's no rule that then can be given. All the relevant factors must be considered before a judicial officer decides whether or not to dismiss a matter for want of prosecution or based on an application for an adjournment or for submissions. All the factors have to be looked into, have to be considered before coming to a decision. I move on now to some other examples. This is in the civil arena. There are certain factors, according to our rules, and I'm sure you have similar rules, that must be taken into account in determining whether to grant an extension. But these factors are not exhaustive. They include promptitude of the application, intentionality of the failure to comply, a good explanation for the breach, and general compliance with other orders. There are other factors to be taken into account and varying weight to be given depending on all the circumstances of the case and the discretion of the judge. I will now quickly go through some other cases. There was a case of Rowley against Ram Logan. In that case, the Court of Appeal found, amongst other things, and I'm sorry I can't go into more details of these cases, there isn't enough time, that greater weight should have been given to the detailed affidavit deposing to all the reasons why there was a delay. Ultimately, the Court of Appeal overturned the trial judge's decision to refuse to extend the time for the filing of a witness statements by the appellant. Then there's a case of the Attorney General of Trinidad and Tobago against Brent Thomas and Specialist Shooters Training Center Limited, Court of Appeal P317 of 2022. The decision of the trial judge refusing the application for an extension of time to file affidavits in response to an application for interim relief was appealed and subsequently upheld by the Court of Appeal. In determining that the trial judge was not plainly wrong to exercise his discretion to refuse to grant the extension of time, the Court of Appeal considered the exercise of a discretion, such as extending time for compliance with an order or the adjournment of a hearing, is done by the case management judge against the backdrop of the goals of effective and active case management. The series of events which occurred in this case were as follows. On the 25th of November in that particular year, directions were given. Counsel indicated that affidavit in response would be filed by the 1st of December. On the 9th of December, on the date of the hearing of the application, the Attorney General made a request for an adjournment because instructions were still being received. This adjournment was refused. This was an urgent application for interim relief. An opportunity was afforded to the parties to file, and they failed to do so. See paragraph 55 to 61 of that judgment. Another example of the way the court might deal with such applications, the case of Singh and others against Sao and others, a civil appeal P269 of 2020, which was an appeal against the decision of the learned judge to grant the respondent's oral application to file her affidavit in response to the appellant's affidavits on the hearing of the respondent's application for committal proceedings / injunctive relief. The Court of Appeal upheld the decision of the trial judge and considered the following. This was a serious application for committal and injunctive relief, and therefore short timelines were given. There were no express sanctions in the court's order, nor was there any prejudice to the appellant, and therefore the judge was not wrong to dispense with the need for a written application and grant the oral application all within his Part 26 case management powers. There was no evidence of general non-compliance, no evidence of an intention to breach the order. There was no negative impact to the administration of justice. So I would like to kind of go through with you now and see if you have any suggestions to some of the issues which we experienced in Trinidad, not all of them, some of them, and how you would approach it, whether you think that these issues or these factors are avoidable delays and can be dealt with by proper case management, or do you think they're not? There's a limit to what the judicial officer can do. And I really hope I have participation. I usually like it to be interactive. So I listed some 20-something factors, or no, it's 32, which usually impacts, in my experience, on the court dealing with a matter efficiently and effectively and preventing delays. So I hope I can have some participation, even though it's not time yet, but I hope I can have some participation from you all. The alternative is, I will first go through, I'll leave that for last. I'll first go through some suggestions which I would like to make for the effective and efficient running of courts. As I said, I don't have all the answers. I might be totally wrong, but I would love to hear your views on this. I have found that one, having a detailed knowledge of a case to be case managed is important so that the judicial officer can explore all the issues and see any possible difficulties that might be encountered in ensuring a smooth flow of the case, because sometimes the actual attorneys might not pick up on all the issues. Secondly, I feel that it's important in case managing of a case to give reasonable timelines to attorneys to address the difficulties that they might encounter in getting their case together. But there must come a point in time when the court gives.
On the beach on Saturday night?
Somebody's mic is on, Ms. Williams. Inadvertently, you probably put on your mic there. So I was saying that in case managing of a matter, I would suggest that to start off with giving reasonable time for attorneys to address any difficulties that they might face in their preparation of the matter. But thereafter, give a firm deadline, which means that the case will move to trial as is. This is a form of sanction, I guess. But you can't wait forever for parties to, in fact, be prepared. You give them sufficient time. I'll give you an example. Very often in case management, as a trial judge, a defense attorney will say, I would like to get the station diary. Now, for some reason, there's always a difficulty in locating station diaries. And so if from one case management day to another, you will have the same issue arising and the same inability of the state to disclose the station diary to the defense attorney. How long would you wait before you decide enough is enough? After X number of adjournments, and I don't want to be prescriptive, it's time to move on. And you have to take the decision that, well, the case will have to be heard without that station diary. So I believe in giving reasonable time to attorneys to address all the issues that they have to face, but at some point, given a firm deadline, which will be kept, and the case should move on to trial stage. The other point is the approach which we use, especially in the Court of Appeal, is that short of death All dates for trials and hearings are fixed. If a person cannot attend personally, it is their responsibility to brief another attorney to deal with the case. No adjournments. I'll give you an example of how we operate this. And you might think it's a bit harsh, but for the system to work efficiently, we have to be very firm in our position. There was a particular matter in which the application was for conditional leave to the Privy Council. And probably the day before the hearing, one attorney wanted an adjournment of the matter. What was the reason for the adjournment? One, the attorneys are not evenly balanced because one attorney was appointed a senior counsel and the other attorney is now not a senior counsel. We said absolutely not. Not a good reason. Second reason was the actual party was not feeling well. They probably had surgery or whatever. We said, no, that doesn't affect anything. You really do not need the party to be present in court. The matter is a legal matter. So we refused to adjourn the matter and we got on with it and be able to deal with it. Another example, on the morning of a matter, a senior attorney says, I can't appear. I have COVID. This was recently. During the COVID period, the court, we were very sympathetic. We knew so very little about COVID, etc. But this was within recent times. So an attorney writes us to us the same morning or very late in the afternoon before to say, I cannot attend because I am ill. I have COVID. We said, we're not adjourning. You either arrange for someone else to appear on your behalf, or we'll send you a link and you could deal with it. We sent a link, the attorney appeared, we were able to deal with it. It was on legal issues. So that is the approach. The approach is no adjournments. That's how we approach it in the Court of Appeal. Another suggestion I would make is zero tolerance on the late attendance of court. If attorneys are late, report them to the Law Association. If they work at the DPP's office, report them there. Proceedings must begin on time. I feel it's disrespectful for people not to observe the time a proceeding begins, because everybody else involved, we go all out of our way to be there on time. In an extreme case, if there's any extreme difficulties because things happen in life, we will be courteous enough to inform the parties there's something that occurred and we're going to be starting late, some 15 minutes, but zero tolerance on late attendance of court. With the new system now, because since COVID, we do have online hearings in the Court of Appeal. And my frustration always is when we have to apologize to the parties because there's some FTR issue or some connectivity issue. I think we have to have some standard operating procedures to ensure that the staff responsible for the system checks on it maybe 45 minutes, an hour before the time of hearing. So we too could comply with starting precisely on time. Another suggestion would be to keep the time frame for the completion of matters. If you say this matter is going to be completed in 10 days, find a way to keep that time frame. Things might happen. You would maybe sit long on a particular day, but let the parties know that the court means business. 10 days mean 10 days. In some jurisdictions, because of the limited courts available, it means if you go over, somebody else is affected. So I would suggest that be rigid in keeping the time frame given for the completion of matters. Ensure during the course of case management to narrow the issues. So there's a pre-trial thing to avoid excessive cross-examination. And in a relevant proceedings, opt for written submissions to prevent unnecessarily long oral submissions. Impose page limits for written submissions where there are written submissions. ensure that there's robust case management pre-trial, but also during trial. Sometimes I feel that as a high court judge, I operated like one of those persons in one of those game shows on television where you have to press a button if anything wrong happens, or if the attorney is going going over the time, etc. You need to keep the attorneys within the time frames agreed upon, because during the actual case management, the parties usually agree about the length of time it will take to examine and cross-examine. Now, you will have to determine whether or not in this particular case I will give some leeway. As I said, I'm not being prescriptive. Every case has to be dealt with on its own particular facts. And the judicial office is the best person to determine when you might give a bit more leeway to an individual. I would also suggest to develop a criteria for each type of case and write it down, because not all cases require the same time frame from start to finish. So for example, a common assault could be dealt with quicker than, of course, a murder, especially a complicated murder. And so I would suggest that, and I suggest this for us as well in this country, that we should give time limits for different types of offenses or different types of matters. But you need to look at the type of matter to determine what time limit is appropriate. I would not suggest using the same time limit for all matters. Also have time limits for each stage of the case. In terms of case management, you don't have to spend too much time on that. The length of a witness's testimony, the length of your final submissions. What I found when we first started to case manage is attorneys were not always prepared. So sometimes it amounted to an exercise in futility. So we need to change the way attorneys and judges look at their role and their responsibility to ensure that everybody's on the same page, so that we use the time we have at each stage, pre-trial, case management, as well as in trial, for the we need efficient use of time. Yes? And there should be some system to monitor the steps and milestones that each case has to hit to meet deadlines. This will ensure the timely delivery of, and the other thing is, we can be part of the problem if we do not deliver our decisions, our judgments in a timely fashion. So we also have to have a strategy and a time frame for delivery of decisions. And again, not all cases are created equal. Some might require a bit more time, some less time. But we should have timelines which we observe. I feel that because so many of us have the issue of backlog, it is not easy to address everything at the same time. I feel that a separate strategy should be applied for cases that are long outstanding, the cases that are 10 years old or more. You decide what period of time, whether you look at cases from 5 years and older, that's up to you. But you should, in fact, have a separate strategy, whether you want to assign a particular judicial officer to deal with those matters, whether you want to divide those matters into sexual offenses, murders. It's entirely up to the particular judiciary to decide how best they deal with the situation. But I'm just suggesting that there must be a strategy, because it's every jurisdiction has a limited number of judicial officers available to deal with matters. And therefore, without a strategy, we can't, in fact, properly reduce, especially the old backlogs. And finally, I think, as with everything else, there must be the judicial officers and the attorneys and everybody involved, the parties, the participants, the judicial officers, must all be committed to change, committed to changing the current culture of our judiciaries to one that is efficient and effective and able to meet its targets in the delivery of justice for all. So these are some of the suggestions that I would suggest. And lastly, there must be a strategic plan overall. So yes, these are, you might not agree with them, but this is from my experience and seeing what happens in our jurisdiction. I saw it in the criminal arena, but I'm also sitting in all appeals now, and I also see it in the civil. One has to have a strategy for dealing with it. It wouldn't go away overnight. I wanted to go on lastly, and feel free to interrupt at any point to give me your views on some of the sources of delay which I have experienced or have seen in other countries. So one, late arrival of prisoners. Is that a problem in Turks and Caicos? Anyone? Anybody practicing in criminal? Is that a problem? Yes, no? Feel free to speak.
Not really. I mean, there have been occasions when there are late arrivals, but for the most part, the accused persons are brought in time.
That's great. So at one stage, we had a difficulty with late arrival of prisoners because they were brought from somewhere in the east. The courts were in a different location, and there were police officers had to come with the prison service, and that has been addressed because thankfully, well, not thankfully, but because of COVID, we now do a lot of online, and therefore the prisoners can stay in their location, and that's no longer a problem. But it really meant that we started a lot later in those days when I was a High Court judge. Secondly, late arrival of jurors or absent jurors. Anybody, you all have that as an issue? Anybody?
Not absent jurors, but sometimes getting a sufficient panel so we could commence juror selection.
So is it because your pool is pretty small?
Pool tends to be small, given obviously the size of the country.
Right. We have that issue in Tobago, and therefore the questions we ask are slightly different. So when everybody seems to know everybody, and so we have to ask, like, so when you say you know the person, how do you really know them? It's just from saying hi and hello, or to what extent? So I understand that is an issue. But because of our difficulty there are always problems with the jurors. If it's raining, jurors come late. Problems with a child, there are always issues. And we can't be sure that the jurors always come in time. And if they do come in time, there is an appointment with the US Embassy for visa or some issue at the school. So one of the things we did is that there was an intervention by legislation, and we now have judge alone trials. But of course, that's if the accused chooses to do that. Another way we tried to deal with the backlog was to have maximum sentence indications, which was always available for us, but we really wanted to reintroduce and emphasize it. And we did so by the Chief Justice sitting one day in the High Court. He asked us to prepare a docket for him. I did it, he came, he dealt with it, and that really encouraged people to consider maximum sentence indications. We also, of course, like you're having in Turks and Caicos criminal procedure rules. We had one in 2016, and then that is revoked by the one in 2023. We also amended our plea bargaining act to encourage persons to consider that as an option as well. And recently, the preliminary inquiries have been abolished, and so now we have sufficiency hearings, etc. We also introduced a docket system, which we felt might help us deal with the backlog as well. Now, this sounds like very minor, but even things like late arrival of lunches for jurors. We used to give jurors lunches. Do you all do that when you have jurors?
Yes, we do.
And is that an issue, or they always come in time?
Yeah, there's really not any
Is that a
problem
problem?
with the no with the target.
Okay, that's good to know. Okay, another one is either the prosecution or the defense, they're not ready to proceed, and they're applying for an adjournment, whether it's due to the fact that there wasn't any proper handover of the matter, somebody, other attorney was dealing with it, they're not prepared, their department didn't deal with it properly, or in the case of the defense, attorneys, they've changed the attorneys, or they're ill. Does that happen from time to time in Turks and Caicos as well?
With the prosecution, sometimes prosecutions, a prosecutor will turn up with and indicate they have no familiarity with the case. No, with the defense on the defense side, the issue we have is that we have a very small bar, very small criminal
Right.
bar. So usually issues that will delay in the terms of attorneys, our attorneys being actually engaged in other matters.
Right, thank you for that. So with us too, we have a very small, we had a very small defense bar. And I actually, sometimes I had to wait on because there are few attorneys who are very popular. And one was doing a matter before another judge. That matter, when it spilled over, I had already started my matter and I literally had to wait for them to finish. Thankfully, we now have a public defender's department, which I will highly recommend because I found that the lack of the few numbers of persons at the defense bar really impacted in a major way from matters proceeding at any pace. So I mean, I understand you all have a duty counsel, and that duty counsel deals with arraignments maybe, and and
That's correct.
yes, but I would suggest, and this is a issue which the executive have to get involved in terms of deciding whether or not they want to put some more resources into it. But that was a game change. That changed things a lot, and now we have that in place. Matters can go on faster.
I mean,
In terms of yes.
we're lucky enough to have a very enlightened Chief Justice, and I believe that is those some of the things I've highlighted are some of the stuff that she's looking to progress.
Fantastic. With the prosecution, we have some excellent prosecutors, but we also have some inexperienced ones. And what happens is the moment they're really well trained, and so they move on, become judges, masters, and different things. So sometimes we have to deal with, first of all, the DPP's department does not have a full complement, and that could cause delays as well. And the persons are overworked. And again, I would suggest that the executive this is something that the judge's case manager cannot really deal with. But I think it's important to highlight it to whoever you report to, so that they decide whether or not the executive will take steps to increase the pool of prosecutors. So some of those things we really can't deal with. If an attorney is out of the jurisdiction, should that happen at all? Or that's something that could be avoided if there was robust case management? What do you all think? I feel it. Yes, go ahead.
We're fortunate enough to have practice directions that, with the court's permission, would allow an attorney who's outside the jurisdiction at a particular time to appear virtually. And
Right. So that deals with that. Great, great. I mentioned it I mentioned it in the course of dealing with certain examples of cases, but what would you do if an attorney wants an extension of time to file submissions? Everybody must, I think we all agree that this is really a case management issue, and it depends on the facts of the particular case. But I feel that there must be robust case management to address such situations. Do you all agree? with applications for extension of time. So, okay, so I'll move on. We also,
Madam Justice of Appeal, sorry, just before you move on, I mean,
yes,
of course, in civil cases, it's Andrew Mitchell speaking, in civil cases, I mean, everything you say, of course, is appropriate because there can be sanctions. But
yes.
what I think we might all benefit from is your assistance on what kind of sanctions there can be in criminal cases, because ultimately, of course, the defendant's right to be tried, and I mean it from the defendant's perspective, if he's delayed in filing his submissions or his counsel has been dilatory, no court is going to prevent those submissions from being filed. And so it may be that there has to be a completely different perspective between civil rights and the rights of a defendant in a criminal trial.
And I agree with you 100%. And at one stage, I believe you mentioned sanctions in our criminal procedure rules of 2016, which has still since been revoked by the rules of 2023. And that was the question which was always asked: what sanctions can we impose on in a criminal case? And it's difficult because you don't want to. It's a different type of case. So I think we need to work on the change in the culture of the judiciary and the way things are done. And we recognize, I noticed in our new criminal procedure rules, there is not sanction as such, but there's still I think underlying it is the whole idea of robust case management pre-trial, and for the judicial officer case managing to ensure at that stage you have all the submissions which are required to move this case forward. I really do not think, I mean, in some cases, submissions have to be made during the course of the trial. For example, for certain types of bad character applications. But I feel that it's a responsibility of the judicial officer to really get the parties to file whatever they could before the trial commences. And as I said, give reasonable deadlines, but there comes a point in time when you give a deadline saying, okay, if you don't, we move forward. Because it can't be, the accused cannot call the shots in a criminal trial. We understand their rights, we understand that they should be given an opportunity, and very often it might be even the attorney. But that's why I feel that in some cases, an adequate, reasonable time should be given for them to get their case together. But there must be at some point in time, you have to say, no, we're moving forward. I can't give you an answer of a sanction. And even in England, I don't think there's sanctions. Are there? Mr. Mitchell?
No, there aren't. Forgive me.
There aren't. So
no.
it's a different attitude, though. You have
it's a very difficult issue when it comes to criminal cases and the rights of a defendant to put his case.
Yes.
And I'm not even sure, with all due respect, that we've got to move on stance of the judiciary really affects or can work if the defendant then, through his counsel, sometime during the trial raises an issue which should have been dealt with some time before, but the issue has to be resolved. And unless there is some professional obligation, and that would be difficult, I respectfully suggest, one is always going to face that conundrum that ultimately the defendant's interests have to be always the ability to put his or her points before the court.
Absolutely. And Mr. Mitchell, as you said, the attorney should feel that professional obligation to ensure that he does that, and in time for the trial.
I agree, and that may be that's where the sanction issue might bite. Forgive me, and that is in professional obligations being imposed on counsel.
Yes, and we need to get buy-in from the defense attorneys to see that it affects them as well if cases go on and on and on. And therefore, they should be encouraged to do their part in furthering the overriding objective. But that was never an easy question to answer. So thank you for that question, Mr. Mitchell.
Not at all. Not at all. Thank you,
Right.
lady.
And a problem we faced here is insufficient experts at our forensic science center to do the usual types of analysis of guns, of drugs, etc. And it leads to delays. I mean, I was so bold in one case where a person was before my court for murder, and I think it was involved murder of kids, and they was left in a house that was destroyed by fire, but the fire was deliberately set. And I started the case. I couldn't wait any longer for the Forensic Science Center. But what I did, I summoned someone from the Forensic Science Center and said to them, how soon can you analyze this piece of cloth? Because it's keeping back the trial. And the person said, like, in 2 months. I said, no, that is not going to work. You need to do it in 2 weeks. And in that way, I got it done. But I mean, it's unfortunate we have to do it that way, but there are resources. That's one example where there are resource issues. And I understand that the executive has since put a lot of money into that, I think through donor countries, to create a forensic science center with more experts who are available, but there's still a huge backlog. I was always concerned about this because it even affects, sometimes it affects people getting bail, because the state will still come and object to bail because of certain things, but they have not yet been able to analyze the relevant item, so that it's not an easy situation. I understand that in Turks and Caicos, there's no forensic entity on the island, correct? It has to be sent abroad.
Yeah, that's correct.
Correct.
And also there's no pathologist based there. So one has to be flown in.
Yes.
So I think, again, this is something which it's for the executive to intervene if they see that that is something they want to do and it's necessary, so that I could see that unless there's an efficient system put in place, it could potentially contribute to actual delays. Another area which I have is probation officer's report. I remember, pre-sentencing, you want a probation officer's report. And because, again, we're understaffed here, it would take more than 6 weeks. Your hands feel really tied. And that's one area the judicial officer is limited in what they can do. And this is one area in which you hope that more resources can be put into this particular department to, in fact, have more probation officers who could give you timely reports, and so that we will not have to adjourn the sentencing of a particular individual. Is that a problem in Turks and Caicos? Probation officers' reports?
I wouldn't say it's a problem. I think based on our experience, we know essentially the time frame in which they will need to produce the reports.
Right.
So both the judges and the parties would agree to adjourn the case to that time frame. It's usually 4 to 6 weeks. And
Okay, which is not too bad.
Yeah.
Yes. And then I understand that we have needs for translators and interpreters as well, but you do, particularly because some of the accused are foreigners, like Haitians, and yeah.
Yes, we do.
Is there a problem getting the translators and interpreters in a timely fashion?
I believe that we need more, because sometimes you have conflicts with more than one court needing an interpreter, plural interpreter at the same time. But we do have, and that's the only issue that I would say.
Right. So it's not for me to say, but I think it's always good to have that kind of discussion with the powers that be to see if there's anything that could be done. how do you all deal with this? I don't know if you face this as well. You want to start a matter, the attorney is ready, but they say that there's a conflict because they have to appear before a higher court. And like when they're in the high court, they have to appear before the Court of Appeal. Should a trial judge give way to and how to the Court of Appeal hearing, which I think they should, but how can we address that? Must there be a dialogue between the Court of Appeal and High Court to prevent that from happening?
Again, Andrew Mitchell here. I mean, you'll know, obviously, traditionally that it always was. If
Yeah.
the obligation is to appear before the highest court that needs you on the particular day, but then there is an obligation on attorneys to make sure that they have communicated those dates so that people can work that out through listing. And
Right.
obviously, it shouldn't be something that therefore comes up the night before a hearing.
Right. So it's a communication problem, timely communication, so that
Exactly.
you will not have that kind of conflict. Yes?
Precisely.
Well, I disagree. I don't really see it as a communication problem. It's more a schedule problem, and the judges sometimes recognize for the most part would recognize the hierarchy and would allow the counsel to appear before quote unquote higher courts.
Right. Okay. So it's not, you don't see it as much of a problem. It can be arranged without delaying the so-called lower court. Yes?
It's only a problem in that, of course, one matter will get delayed, and of course that's what we're trying to prevent. But in terms of working out where the attorney should go, I believe our courts have dealt with it effectively.
So that I am agreeing with both of you, and everyone knows too. Normally you go before the higher court, but I feel that we could think of ways in which, I mean, I think Mr. Mitchell said it. We could have some sort of communication so there isn't that conflict, because if that happens a lot in the lower courts, whether it's magistrates court or the high court, it could keep on delaying the completion of that particular matter. So I don't have the answers, but I feel that there must be some way of communicating communication between the different judicial officers to accommodate the matter in the lower court happening and also the appeal court, not on the same day, but if they knew about it before. So it's a matter, that's why I thought it was a matter of communication.
Yeah, in my experience, the typical situation where that occurs is where you have an overrun of a trial,
Right.
and sometimes there may be a new arrest in magistrate's court that you like to pop in to take care of before you commence your trial. And as I said, most of the time the courts are kind enough to allow that.
So I like that you say that, Mr. Smith, because you speak about an overrun. So I feel that the judicial officers should try their best to prevent that overrun because of the consequences and implication of that to other matters. So thank you for that. Of course, sometimes I remember as a prosecutor, you served late with an alibi notice. It comes back to what the discussion I had with Mr. Mitchell. I think that the defense attorneys need to recognize their obligations. They take written instructions, and therefore, because they must also actively assist in obtaining in the overriding in objective, they should try to avoid this happening because it could in fact delay the matter. It results in the need for the state to investigate, and something that puts the case back a week or two. So I think defense attorneys must also recognize I feel, the role they play in encouraging their clients to provide that information at an earlier stage. When you, I think as a young judge too, what tends to happen is sometimes you allow the parties to go on and on and on in their cross-examination, and sometimes it's on irrelevant issues. But hopefully with time, you learn how to grapple with that. And it does help to have proper case management where issues are narrowed. So my experience when I used to be a high court judge was very often the attorneys only begin preparing the case when the trial begins. So to make up make up time to have more time to do their preparation, they would sometimes engage in cross-examination in relation to irrelevant issues. And in those days, we didn't have proper case management, and therefore the issues were not narrowed. So you'd have this, the typical one was, Mr. Mitchell, I don't know if you practice, yeah, you would have practiced in Trinidad, but when a defense attorney spends a long time cross-examining on pocket diaries, oh my God, or a photographer, or a person who ID'd the body, it's really, really, really irrelevant. But, and I think that this is something which judicial officers have to grapple with, and they could only do so if they know the case inside out, if they have case managed to know what the narrow issues are. And of course, they're getting agreement from both sides. These are the issues. Identification is the issue in this case, So I think that helps. We have issues sometimes with at the time I was a high court judge, with psychiatric assessments being done in a timely fashion, and a lot of accused persons are affected because the cases can't go on. And when I investigated, it was a lot of murders, and so sometimes eventually we arrange a system whereby there are focal points at the mental institution and the court, and we were able to provide the information they required from their relatives, and that made a huge difference. But it's something that's very often it comes down to communication. So the last thing I have is sometimes the issues with judicial officers not giving their reasons in a timely fashion, and that affects in the case of civil matters, let's say appeals, we can't deal with the appeal effectively with the reasons. So that it's another reason, and it could be considered. And I think I've largely covered some of the issues which I think might result in delays, but I still believe that with robust case management, from the day the case, from pre-trial as well as during the trial, could in fact result in more efficient hearings. Definitely, I think we need to have a culture change. It happened in our civil arena, and maybe it's happening, I don't know, in the criminal, but it's the judicial officers who I feel must lead the way to ensure that happens, just by doing their really robust case management, and just letting everybody know, as I've just said, it impacts on everyone. So it's not just the judicial officer bullying parties into doing this, but I think everyone benefits. The whole system benefits, and it prevents some of the consequences which I have seen, which I've stated, for if one does not deal with and try to address the efficient and effective management of courts and court matters. So that's what I have to say. Does anyone have questions? It's now 11:48.
Good morning. Yes, we have just about 5 minutes for questions or any comments from
Yes.
participants. I see we have Ms. Tennant.
Good morning, and I wish to thank Justice of Appeal Wilson
Yes.
for the very informative presentation. I thoroughly enjoyed it. But just two observations which I think caused delay in the Turks and Caicos, which I think is particularly unique to the Turks and Caicos.
Yes.
One, travel between islands. So from time to time, yes, attorneys have to travel to Grand Turk for trials, and that is not always predictable. So flights get delayed, flights get canceled. In turn, the trial is affected.
Okay.
Also, you touched on it earlier, the availability of interpreters. The use of interpreters where you have a litigant who does not speak English severely extends the trial. So every word has to be translated. And in turn, you have a witness that would normally take probably half an hour end up being 3 hours long. So those are two observations I wish to make. Thank you.
Thank you very much. And Ms. Tennant, do you have any suggestions, any solutions? I like to try to resolve things. Any suggestions to the travel difficulties between the islands? I know it might not be within the purview of a judicial officer or an attorney, but how do you think that could be addressed?
Well, I believe Casey Smith alluded to our practice direction, which allows attorneys to appear virtually.
Yes.
So we try to make use of that. And also, but there are some instances where you would like to be there, particularly in criminal cases for jury
Yes.
selection and that kind of thing. So
Yes.
sometimes it's unavoidable, and we're pretty much sometimes in the hands of the airlines as to our availability. But the practice direction where we're able to attend virtually helps significantly in alleviating that issue. In
Yes.
terms of the length of time and estimating length of time a trial may take where a litigant is not an English speaker, I think with time and experience that we'll be able to judge that more accurately.
Yes.
And it will vary from case to case, because you have some who do speak some English, and so the case is able to progress much more quickly. And you have others who are just not able to understand, and such cases will take much longer through an interpreter.
Okay. Thank you so much.
Thank you.
Any other questions? And what would you say are the main causes of delay in Turks and Caicos? Because I am impressed by the criminal procedure rules that you have. You know, but as I said, it depends on the how the judicial officer manages his court. Yeah.
I have a question.
Yes.
If you can provide some guidance on how do you deal with it or advise your clients when the delay is attributed to the judicial officer, where, for example, a trial date has been set and it's the day of trial or the day before trial, and you've been notified by the court that the trial needs to be adjourned for whatever reason.
Okay. Does that happen a lot?
No, I won't say happens a lot, but it has happened to me in practice in Trinidad, Your Lordship.
Yes. That's obviously the client will be very upset, but I feel that with this culture change, which I'm suggesting, that the judicial officer will be more mindful about the fact that no, trial dates and hearing dates should be firm dates, and it's a client should have the expectation that their matter should go on. So it really should only be in extreme certain circumstances when that date should be changed. So I feel that there's need for dialogue amongst judges, and for everyone to come to that conclusion that one cannot simply change the date of the hearing. I see a client will always be upset, so I can't suggest a way of you tell them directly, I only got a recent notice, but it should not be like that, because as I said, it's horrible for the client because there's no finality. They do not know when their matters will come to an end, and that's not a good state to be in. So that's my response to that. I saw that someone had disclosure, and I did have that amongst my list, but I went through really, really quickly. It is critical for disclosure to take place at a very early stage, a pre-trial stage. And you don't want in the middle of a trial, it's like the alibi notice. You don't want in the middle of a trial to obtain disclosure, because in those circumstances, most judges will give the other side, the defense, time to look at it and consider it. And it could potentially lead to an adjournment and a delay. So that I feel that all the parties involved should get together and have a conversation about moving forward and improving the efficiency of the, not just the criminal process, but the administration of justice. And we need to have buy-in from everyone, because it's like all hands on board. It's not just the judicial officer. Everyone must be willing. The parties have to actively assist in obtaining the overriding objective of the rules, and so as to avoid some of the consequences which I think might result if the system is not efficiently run. Yes,
Thank you very much, Judge. I think
yes.
there's time for just one more question or comment.
May I just ask a question of you? And that is
Yes.
simply this. During your very detailed presentation on the authorities, the screen had the original case that you referred to and didn't then move on, at least on my end, to the
Right.
other cases. And I'm hoping that you may be able to supply those
Is it,
to us.
in which, are you referring to Burgess, Justice John?
Yes, it was that one that I
Right.
was interested in.
And that's very interesting too. It came up in a matter which I heard recently, but the point is, because some magistrates, as an appeal to be heard, feel that, well, the other side felt that some magistrates are using the Burgess matter as an excuse for not dismissing matters. And one of the questions which I think we need to look at is, is there any conflict between the Burgess matters and this new way of dealing with matters through our criminal procedure rules? Is there any conflict between Burgess and our criminal procedure rules, where we want to have more effective courts and running more efficiently? Is because that's an old case, huh? So,
course.
but when I looked at it, I felt that the larger point that Justice John, and he's Justice Stanley John, was making is that you need to take into account all the factors.
Yeah.
You can't just hold on to the fact that about the attendance of the complainant. That would not be fair. That would not be a reasonable exercise of one's discretion. And I feel that most of the cases, whether it's criminal or civil, you look at the factors under the civil procedures rules that you must look at, and then having regard to all the facts of that particular case, applying those factors, whether or not one could deal with the matter, say that the person acted unreasonably or did not comply with this requirement of this particular rule, as I showed in the first case. And in the Burgess case, I think the only point he was really making is, don't hold on to one factor. Look at everything. Look at it in its totality before quickly deciding to dismiss, because there are lots of factors which would tip the balance on the other way, the other side. So I could provide that authority. It is actually Magistrate Appeal number 98 of 2008.
Thank you.
Diane Burgess against Thalia Civilton. And I'm happy to provide, my notes, if you wish, that I prepared for this presentation, or the PowerPoint. But the notes are, I prefer, yes.
Thank you very much.
Okay.
So thank you very much, Justice Wilson, for that very informative presentation. I'd now like to introduce Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, to give a formal vote of thanks.
Thank you.
Good morning, everyone. Thank you, Antonio, and thank you, Justice Wilson. Justice of Appeal Wilson, we say thank you on behalf of the JEI TCI for a thorough and detailed presentation on courtroom management and avoidable delays. Your in-depth knowledge, practical tips, and discussion of strategies to reduce avoidable delays were extremely valuable. No doubt our judicial officers present appreciated the way in which you addressed the challenges and provided effective strategies for maintaining order and efficiency in the courtroom. And going forward, I'm sure they will adopt some of the tips you share in the conduct of their respective daily court duties. Likewise, the attorneys present would have gained a better understanding as to how they can take control of their cases, and so that they ensure that they are better prepared so as to avoid delays. So once again, we wish to say thank you for taking the time to share your knowledge and experience with us this morning. I now hand this back over to Mr. Emmanuel, who will formally close off this morning's session.
Okay.
Thank you very much, Ms. Carter. So that brings this morning's presentation to a close. We thank you very much for joining us. We ask all participants to please complete the feedback survey before you exit the meeting, and we look forward to your attendance this afternoon at 1:30 while we'll explore judgment writing in criminal cases. So thank you very much, everyone, for continuing to attend JAI Week 2024.
Thank you.
Thanks, Judge.